Welcome everybody, and thanks for joining us today. My name is Flynn Robson, and I look after private clients. I just want to say thank you for joining us today. I really appreciate you taking the time on what is definitely something that comes up a lot when we talk about particularly investments offshore. As I'm sure you're aware, everyone that is looking to invest is looking at ways to diversify their investment portfolios and looking to go offshore. And as you do that, you create different challenges, should we say. There are challenges, but most challenges can be overcome with the introduction of knowledge, and those knowledge, that's the reason we have these seminars, to impart our knowledge. And we have two very knowledgeable people join us today. Sarah, who heads up our trust and fiduciary business at Simson, and Stan, who's joined us today as well, will be taking us through most of the presentation today. We'll be talking about Situs and probate and how these affect your investments, and what we need to know going forward, particularly when we're investing in the US. The universe is immense. As we all know, there are lots of places we can invest into, and there are lots of places we do invest into. But I think the best way to almost eat this elephant is one spoonful at a time. So we'll start with one section of investments today, and then as we roll through the series of presentations, I'm sure Sarah will start going through different jurisdictions and the different impacts on the investments that has in that space. But without further ado, let me hand over to Sarah. And we will have Q&A. There's a chat function and a Q&A function. This is being recorded, and Stan has kindly agreed to send through the presentation afterwards, which we'll share post the presentation.
Thank you, Flynn. There are quite a few online sessions on this topic, but today's session has been specifically structured around commonly asked questions by our own client base with regards to specific asset types. With a more heavily weighted concentration of assets offshore, we would be most remiss not to focus on cross-border estate planning implications of a diversified portfolio. And that is the reason for having a very focused approach and looking at the US in isolation instead of combining all the different jurisdictions that would be affected. Now, one of the most common questions relates to offshore portfolios. Most portfolios comprise of US shares, but don't be too quick to go and analyze your own portfolio, because many supposedly US companies that are presumably synonymous with the US have interesting buffered layers of ownership that aren't actually defined as US corporations. Now, this session is not intended to make any of the attendees experts on Situs overnight. We are trying to demystify the concepts that you may read about in the media and to create investor awareness, rather, on this topic. Now, there are a myriad of solutions for the issues raised in this session. Today's session is intended to highlight awareness of legal concepts and not to provide you with solutions, whether legal or financial. Our aim is really not to focus on products and services today. I would rather encourage you to chat to your portfolio manager or your client relationship manager if you have queries, or to involve the services of one of our fiduciary specialists. Joining us shortly is Stan Bach, who is a partner at Kosciuszko Harris Duncan. Stan is a practicing solicitor in New York and 2 other states in America. He really is an absolute expert on US tax law and estate planning, with a particular emphasis on planning for international families. Apologies, Stan, I've had to summarize and abbreviate your many accolades and accreditations, as we only have 1 hour for this session. Now, Stan is a member of STEP's Worldwide Council. He is the immediate past chairman of STEP USA. In addition, he is a member of the American Bar Association's Taxation, Probate and Trust Law Association and the International Tax Planning Association. Now, the question begets asking, why Stan? And the reason for that is, whilst many attorneys go out of their way to wrap concepts in legalese, Stan goes out of his way to simplify concepts into practical scenarios that are understandable to everybody. And he has a vast amount of experience in his field. So without further ado, I am handing you over to Stan Bach to take us through US Situs tax. Welcome, Stan.
Sarah, thanks so much for the introduction, and thanks to you and Flynn for inviting me to join you today. This is an interesting area. It is becoming one that people are more aware of, I'm finding, as time goes on. It was just about a year or so ago, I was asked to speak at a conference, and they said they wanted me to speak because there were new rules that if people from outside the United States invested in US securities and shares, that they were subject to US tax on that when they passed away. And I said, well, I'm very happy to talk about that, but there isn't anything that's particularly new about these rules. They've been around for a long time. And the reply was, well, that may be the case, but now they seem to be enforcing it. So all of a sudden, everyone's all worked up about it. As I say, this is a very interesting topic, and one that seems to be of increased interest over the last few years. There are a lot of nuances in connection with how these rules work. And so before getting to the specific assets that are involved, because there are a lot of issues with respect to the specific assets, and we will get specifically to them, I want to discuss the tax in general that we're talking about and who is and isn't subject to it. Because a lot of the planning that we do in this area, in order to understand it, I think you need to have some understanding of how these rules work together. And so it's worth spending some time so that you can understand how the rules work in context. When we're talking about this situs tax, what we're essentially talking about are the US transfer taxes, which are basically US estate tax and US gift tax. The US has a gift tax that applies to donative transfers during lifetime that exceed a specific exclusion amount, which I'll come back to in a second. And the estate tax is a very similar tax, but applies at death. Both taxes do not apply to the recipient, rather they apply to the donor or the decedent's estate, as opposed to the recipient. Now, having just said that, there is one exception that I do want to mention with regard to it, because it does come up and can be quite relevant, is that if you have an individual who is what we call a covered expatriate, a wealthy citizen or long-term resident of the United States who leaves the United States, and then after leaving, they leave assets to their children or grandchildren who might be US citizens, or otherwise resident in the United States. In those circumstances, you can have a tax that applies to the recipient. That's a specific exception to the rule, and basically the only one that does apply. So it's the donation or the bequest where the tax is imposed on the donor, or as I say, the estate of the decedent. Currently, for residents of the US, these taxes apply on worldwide assets. Situs isn't really a question. If I, as a US citizen, own assets in South Africa, or if I own assets in the United States, the estate and gift taxes apply on the same basis, regardless of where the assets are. Doesn't matter. But if you're a non-resident of the US, you're only subject to these taxes on US situs assets, and that's where the question is. That is, if one is a non-resident of the US, you're living in South Africa, for example, the US doesn't care unless what you're giving or you're bequeathing in your estate is what we call a US situs asset. So that's where the situs rules come in. Now, these taxes are reasonably onerous in their rate. It's a 40% tax rate. Some places have higher rates, but we're roughly at a 40% tax rate that applies to the value of the assets at the time of the gift or the bequest. But our exemption for residents of the US or citizens of the US is quite broad. It's right currently, you can pass on up to $11,700,000 US to your heirs before you're subject to these taxes. So it applies to your worldwide assets, but only if those assets are in excess of $11,700,000. There are a number of proposals to reduce this. In fact, without any changes, it will be reduced after 2025. But and I'm going to try to leave some time to get to that at the end. But if you're a non-U.S. person with U.S. Situs assets, the estate tax exemption is only $60,000. So if you're a resident of South Africa and you have U.S. Situs assets, the only exemption you have before you get to the 40% tax is $60,000. So that doesn't take you very far compared to the other exemption. And what I want to point out as a practical matter is that don't necessarily assume that what you want to do is be a non-resident of the U.S. for this purpose. We've seen a number of situations where people have gone to great lengths to try to make themselves non-residents of the U.S. for estate and gift tax purposes, when they would be better off as residents because they have reasonably significant assets in the U.S. when you look at their worldwide estates, and their worldwide estate is less than $11,700,000. So sometimes the most effective plan for some people who do have a foot in the United States is just have them be U.S. residents for U.S. estate and gift tax purposes. And I'll talk about that again in a few minutes. So that's where it can become important whether you're a resident or not, and don't assume that you necessarily want to be a non-resident, because we do find sometimes people have not gotten advice in this area and they've gone to great lengths, as I say, to try to make themselves a non-resident when they really didn't have to worry about these taxes to begin with. And so it's not as much of an issue. All right, so who is regarded as subject to tax on their worldwide assets as opposed to just their situs assets? U.S. citizens and those who are domiciled in the U.S. are subject to these transfer taxes on their worldwide assets. So that is, it applies to U.S. citizens and those who are U.S. domiciled. Otherwise, you're a non-resident for this purpose, and I'll go into that in a bit more detail in just a minute. The other thing that you have to watch out for is who is the owner of these assets that we're talking about here in these circumstances. And that's a very interesting question in and of itself, because for U.S. purposes, what they're looking for is who is the actual beneficial owner of the assets that are being transferred, whether it's a death or during lifetime. If somebody's purely a nominee owner, then that person won't be respected as the owner for U.S. tax purposes. If property is held jointly, let's say with one spouse, then and you're giving it away, or one spouse dies, then okay, what's actually being transferred? What's owned by each spouse? These can actually be very interesting and challenging questions, particularly if you have a married couple, for example, and one is a U.S. citizen and the other is not a U.S. citizen, and who owns what property. And sometimes it's not altogether clear exactly who the owner of the property is. In addition to joint ownership, there can be community property ownership, so that one can own property or have an interest in the ownership of property that they don't even realize that they own. And the questions as to what law applies with respect to who owns what property can be very interesting and not very developed, I must say. There's been very little thought given to these issues historically. Community property can mean a lot of different things in different jurisdictions. Presumably, it's the governing law is where the couple is living, but sometimes it can relate to where the asset is. And each jurisdiction, again, may have its own rules. If you look at the U.S., these rules are governed by state law, actually. So just within the U.S., we have 50 different sets of rules that can apply with regard to this. So in looking at it, it's important to determine who's the owner of the property in question and what is it that they own. And we'll get back to this when we talk about the situs rules specifically. And as part of it, it may be useful for couples to have separate wills for the United States if they own property in the United States. The probate process in the US, and this is one of the things I wanted to talk about and focus on, can be quite cumbersome. Again, the probate process is generally governed under state law. And what happens is that if you're, let's say, a resident of South Africa and you pass away owning a US Situs asset, and let's say it shares in a US company, let's say it's Amazon or Apple or something like that, there may be a broker in the United States who's holding those shares for in what might be a typical example. Well, if you do, that person can be personally liable for the payment of the estate tax that's due with respect to the transfer of those shares. So those individuals will not generally permit a transfer of those assets unless they have good clearance that all the taxes with respect to that have been paid. Which may require opening a separate probate in the United States in order to get the clearance, file the necessary tax returns that need to be filed, get clearance from the Internal Revenue Service so that the individual who's holding the shares in question is not going to be personally liable, and they won't let you transfer it to their heirs. And I must say, you add this to the complication of dealing with the U.S. Internal Revenue Service, which is not the most efficient agency in the world, even on a good day. And particularly after COVID, it's become very challenging because we're not past it. A lot of the government offices are still closed and that sort of thing, although they're starting to reopen a bit. And there are circumstances where you need to get what's called a transfer certificate, a certificate from the Internal Revenue Service. Sometimes it's just easier for our clients to have a separate U.S. will to govern their U.S. assets, particularly if it's something like real estate. So that is something to keep in mind because it does sometimes make the local probate process easier in order to take care of the administration you need to in the United States. When we're dealing with countries where they're speaking a different language on top of it, that can add to the complication, I must say. An issue we don't usually have too much with South Africa, but do with some countries. And dealing with getting the translations and such for the necessary documents can be a burden in and of itself. So again, one way to solve this is sometimes having a separate rule. Okay, I want to spend a couple minutes talking about who is and isn't a U.S. resident for purposes of these taxes, so that we have, again, some understanding of who's covered by these rules and who isn't. Citizens, as I said, are subject to U.S. estate and gift taxes, regardless of where they live, and regardless of even if they know if they're a citizen or not. There's said to be about 6 million American citizens who live outside the United States, who don't even live in the U.S. I would guess the number may be higher than that because there are a lot of people who are U.S. citizens who may not even realize they are. And so that's an important thing to keep in mind, that citizens are subject to tax. And that also applies to income taxes, I'll say. If you're a U.S. citizen living outside the U.S., you're subject to U.S. income tax the same as I am living in the United States. You get a credit for any foreign taxes you pay, such as South African taxes. And sometimes the income tax rates, for example, like in South Africa, may be higher than the tax rates in the U.S. but that doesn't mean we necessarily tax the same things at the same time. And so that can be a factor that you have to take into account in looking at these rules. Residency for estate and gift taxes, as I said before, is based on domicile, whether you're domiciled as a U.S. person. And that's generally living in the U.S. with the intent to remain living in the U.S. Domicile can be defined differently in different countries, but for U.S. purposes, as I say, it's generally living in the U.S. with the intent to remain in the U.S. I'll come back to that in a couple of minutes and go into a bit more specificity with regard to it. For income tax purposes, just so we don't get confused, because people have heard about this and sometimes they get confused about it. Other than citizens who, as I said, are subject to income tax on their worldwide assets, if you're a U.S. resident for income tax purposes, you're also subject to income tax on your worldwide assets, and that's green card holders. If you have a green card, you're automatically subject to U.S. tax for income tax purposes, or if you meet our substantial presence test, which is the 183-day test that you may have heard about, based on the amount of time you're in the United States. The domicile rules that apply for estate and gift tax purposes are sort of separate. If you spend a lot of time in the U.S., that might be evidence that you're domiciled in the U.S. But it doesn't necessarily mean you're domiciled in the U.S. And if you have a green card, you're generally presumed to be domiciled in the U.S. If you pass away holding a green card, but it doesn't conclusively mean that you're domiciled in the U.S. And there have been cases with people in the U.S. with green cards who have been held not to be U.S. domiciled. And similarly, there have been cases of people in the U.S. with a temporary visa so that they couldn't stay in the U.S. for forever if they wanted to. And yet those people have been held to be domiciled in the U.S. because of the way they've conducted their affairs, that it's assumed that they're going to remain in the U.S. So there is a lot of subjectivity when you're dealing with domicile questions, and you don't want to get it confused with the income tax issues, because you can be resident for income tax purposes and not estate and gift tax purposes, or vice versa. And you have to look at both of them separately. There is treaty relief that can apply in some circumstances, and so it's good to keep that in mind. It doesn't typically help citizens. People who are citizens are going to be subject to tax no matter what. The treaty just doesn't help them too much. But particularly for green card holders, it can be helpful in getting relief. In the slides that I have, I do go into a bit more detail on some of these rules, particularly as they apply to income tax purposes, but I don't want to waste too much time on it today because it's not the income tax that we're particularly focused on here. But I do want to be sure, though, to distinguish between the two, so that there isn't that confusion, because there is a lot of times where people hear about a part of the rules, they think it's going to apply to them with respect to these transfer tax issues, and they may or may not, depending on the circumstances. So just keep that in mind. As far as citizenship goes, if you're born in the U.S., you're a U.S. citizen. And so that's why we tend to find a lot of citizens. People may be born in the U.S. And maybe haven't lived very much of their life in the U.S., but they're still born in the U.S. and therefore subject to estate and gift taxes as well as income taxes for their lifetime. Keep that in mind. There are a lot of people who are U.S. citizens who don't even realize they're U.S. citizens, or who are U.S. citizens and maybe didn't even know they were U.S. citizens. They're U.S. citizens because their parents were U.S. citizens and they lived in the U.S. And in planning and in looking at individual circumstances, we work a lot with immigration lawyers in the US in order to make some of these determinations as to citizenship. I wanted to say a couple more words about green cards, because I know that there are a lot of people in South Africa that are holding US green cards. Remember I said before that if you have a green card, you're automatically subject to income taxes on your worldwide income, subject to treaty relief. There is treaty relief that can be available for green card holders. But if you do take advantage of that, that can have an impact on your US status, particularly if you ever want to become a citizen in the future, if you try to take advantage of that treaty relief. So I just wanted to be sure to mention that, just so people could be aware of it and know that that is an issue to look at. And as I said, if you have a green card and you pass away, you're generally presumed to be domiciled in the US and therefore a US resident, but doesn't always necessarily apply. As I say, there are a lot of people with green cards who aren't necessarily spending all their time in the US. The substantial presence test, I don't want to take any time with discussing the details, but again, that's an income tax test if you have heard about it. As far as domicile goes, there is no bright line test in the US for who's domiciled in the US. The US will generally look at factors such as where is your residence located, where's your family located, social, professional, and political organizations you might be connected with, where your investments are, where your business interests are, whether you're a green card holder. As I say, all those things are circumstances that one might look at for determining if one is domiciled in the US. And again, the lines are not clear with regard to that. Okay, so let's say that you've gone through all that and you've determined that you're a non-resident of the US and you're not a citizen of the US, and so you're only going to be subject to US tax on your US Situs assets. And so what are we talking about as far as US Situs assets go for this purpose? And what is and isn't subject to the tax that you're going to have to pay tax on here in looking at these different tests here. For gift tax purposes, as I say, this applies to assets that you give away. And for estate tax purposes, it's assets that you leave at the time of your death and pass on. And what's taxable for purposes of the gift tax and the estate tax is not necessarily the same, which doesn't help. For gift tax purposes, the tax applies to gifts of real property and tangible personal property located in the United States. So it's real property and tangible personal property that's in the United States. For estate tax purposes, there's a significantly broader class of assets that are subject to estate tax. And so that's where we'll get into the rules, because the estate tax is broader than the gift tax. The one thing that means, and this is part of the planning in this area, is that if you have certain assets, you can give them away during your lifetime without being subject to gift tax in the US. But if you continue to hold them at your passing, then you'll have an issue. Real estate, as I said, that's subject to both the gift tax and the estate tax. So if you own it, you can't easily just give it away and get rid of it, because then you'll have the gift tax to deal with. And so for an asset like that, it's particularly important to get your planning done before you acquire the asset. And for all of these, I would emphasize that I think it's a good idea to do the planning before you actually acquire the asset. But you have a bit more leeway generally for gift tax purposes than you would for estate tax purposes. for things like shares and that sort of thing. All right, let's go through some different assets here and talk about what's a US Situs asset for what purpose and where do we run into questions with them. First is cash. You'd think that would be relatively simple. Unfortunately, it's not particularly simple. But cash, if a non-US person has cash in a non-US bank, that's clearly not a US Situs asset. If they have cash in a US bank account, then that's also not subject to US estate tax or gift tax for that matter, but I'll talk about that in a moment, because if you try to give actual cash away, that can be a problem. But if you die with the US bank account, you're not going to pay estate tax on the cash that's in that bank account. Some of the rules here don't necessarily make sense, as when I get to the gift tax issues with respect to gifts of cash in a moment, you'll see. But but this is largely a matter of public policy. The IRS wants to encourage people to deposit their funds in US bank accounts, and so it's fine to have cash in a US bank account. If you happen to have cash in a brokerage account as opposed to a bank account and with a US broker, that's not good. That's regarded as a US Situs asset because it's a bank account. And I think sometimes the lines aren't clear as to what type of account it's in. But if it's in a bank account, it's okay. If it's in a brokerage account, that's not so good. Gift tax, as applies to cash gifts, can get a little bit complicated. If you come into the US with actual physical cash, if somebody were to come in with a suitcase full of cash and give it to their child who's living in New York or any place else in the United States, that would be regarded as a transfer of tangible personal property. Now, I don't know anybody that travels around with suitcases full of cash, but if one would do it, that would be regarded as a transfer of physical, tangible personal property and would be subject to gift tax. Where we see this come up as a practical matter is you have, for example, parents living in South Africa that want to make a gift to their children who are living in the United States. Excuse me, and they want to wire funds to them. And the question is, we frequently get asked, okay, is that going to be subject to any US tax when my child receives this gift of cash that I'm wiring to them? And the short answer is, unless you're a covered expatriate, the child isn't going to be subject to tax on the receipt of that. But you, the donor, may be subject to a gift tax on that for having made a transfer of a US Situs asset. Now, you would think that if you just have cash sitting in an account, I don't think of that as tangible personal property in the US. But the IRS has concluded, for example, that if you make a wire transfer of cash from a donor's US bank account to a donee's US bank account, that is deemed to be a gift that's subject to US gift tax. I could argue against that, but the IRS has ruled that, and I do know of circumstances where they've tried to collect tax on that, on those types of transfers. So if you're in South Africa and you have a US account and you want to make a gift to your children in the US, you don't want to transfer the gift from your US account to the child's US account. The best thing to do is, if the child still has a foreign bank account, to transfer the assets from your foreign account to the child's foreign account, make the wire transfer that way, and then the child can just bring the cash into the United States. So that's the best way to do it if your kids who are living in the US still have a foreign account. is to make the transfer from your foreign account to their foreign account and do it that way. If the transfer goes from your foreign account to the child's US account, personally, I think there's an excellent argument that that's not subject to any, that wouldn't be subject to any gift tax in the US, that it's not a US Situs asset, that there is no tangible personal property in the United States that's being transferred. And I also don't know of any circumstances where the IRS has actually tried to collect tax in those, in that circumstance. But I will say that it's the kind of thing that lawyers in the US worry about. And it's because of some of the language in the rulings relating to transfers from US accounts as to when the gift actually takes place. In some of those rulings, they seem to imply that the gift takes place when it hits the US account, which would then seem to imply that it could apply, the tax could apply if it comes from the foreign account as well. You know, again, I think one could make a very good argument that there should be no gift tax in that circumstance. I don't know of any circumstances where the IRS has actually tried to collect it, but I do know that people worry about it. So best to avoid it if possible. Okay, let's talk about tangible personal property. Again, as I said before, that's also subject to both gift and estate tax if it's in the United States, tangible personal property. If it's physically located in the US, such as cash, jewelry, art, those kinds of things, they are subject to US estate and gift tax if transferred while in the United States. You know, I run into circumstances where people buy apartments in the US, for example, and they want to bring their art in and have it hanging in the apartment. Well, they've added a tax on their passing if the art is still here when they pass away. There are some limited exceptions that can apply for people who are only temporarily in the US and passing through and might pass away while they happen to be passing through the United States. But they're pretty limited. There's also an exception for art that may be in the US for exhibition purposes in a public gallery or museum. There's certain exceptions that apply to that. But it is one of those things that if you do have valuable, tangible personal property in the United States that you want to pass on, you might want to remove it from the US before you decide to pass it on to your kids. So that you're not subject to gift tax if you do it while you're alive, or estate tax when you pass on. Because you do have circumstances like that where the tax is imposed. Now let's talk about financial investments, corporate shares. The general rule is reasonably clear, but it can get complicated depending on the specific assets involved. The general rule is if you're a non-resident and you own shares issued by a US company, that's a US Situs asset for estate tax purposes, not for gift tax purposes because it's an intangible. But if the shares are issued by a US corporation and you own them, they're going to be subject to US estate tax. Now, what clients frequently do to avoid this is put them in some sort of trust that would be effective to keep them out of your US estate. It would have to be what we call a good, qualified US trust for this purpose, or sometimes just use a blocker company to acquire the shares, in which case you have to be sure that the company will be respected. But it can be very effective in planning to avoid this if you think it's going to be a problem. And we have a lot of clients who do that with respect to shares, and it's also effective planning for real estate when we get to that. Shares in a U.S. corporation that are held by a nominee or in street name or under some sort of agency agreement will again be deemed owned by the real equitable owner. You can't avoid the tax just by doing that. If the company's not U.S., then we don't care if you own that. That's not a problem, even if the share certificates happen to be in the U.S. Where the share certificates are isn't relevant for this purpose. It's the company that issues them. Now, the rules are different for partnerships, as I'll come to in just a moment. But as to, there's not everybody just invests directly in shares of a particular company, and there's lots of different ways you can invest in the market, and I just want to mention some of them. On some of these we have rulings, and some of them depend on how it's set up. ADRs, or what are referred to as American Depository Receipts, are generally set up through foreign companies, and therefore they're generally not regarded as subject to U.S. estate tax. ETFs, on the other hand, depends on where they're set up. Sometimes they're set up in the U.S. and sometimes outside the U.S., and that can make a difference, that's what the determinative thing is as to whether it's subject to estate tax or not. Unit investment trusts, you have to look at the trusts. Those are generally set, or whatever it is. They may be called that. Sometimes they're companies, sometimes they're partnerships, sometimes they're corporations, and sometimes they're actual trusts. And you have to look at the trust and see if it actually qualifies or not. But these investments can be quite complex when you look at them, and there's not just sort of one standard way in which they are typically set up. And so you have to look at the specific ones that you're dealing with and see exactly how it works. If, as to mutual funds, for example, assuming it's set up as a corporation and it's set up as a non-corporation, then you shouldn't have a problem. And generally, the people who set these things up are aware of these rules and will have looked at this and made sure they set them up right, so that they're not a problem for non-U.S. residents who buy into them. But when looking at the entity, you have to be sure that the entity is a corporation for U.S. purposes. If it's some sort of limited liability partnership or limited liability company, then you have to look and see how that entity is classified for U.S. tax purposes. And in which case you may need to look through it, and I'll come to partnerships in just a moment. But if you're going to hold U.S. assets through some other entity, you want to look at the other entity, see what it is, and make sure it's been evaluated and looked at carefully for U.S. Estate tax purposes. For income tax purposes, I'll just say this isn't necessarily a problem. If it's a non-U.S. person and you're going to sell shares of a U.S. asset, you're not going to owe tax on that, income tax on that. But for estate tax purposes, you could. And again, you have to look at the entity specifically. The complication as you get into some of these different types of entities with respect to partnerships, for example, is that the IRS hasn't told us exactly how they treat a partnership for purposes of these situs rules. Do you treat the partnership itself as an entity? In which case, if the partnership is foreign and you hold U.S. assets under it, then you're not subject to U.S. estate tax on it? Or do you look through the entity? For income tax purposes, we have a relatively new rule that if you own an interest in a partnership that owns a U.S. business, you can be subject to U.S. income tax on that. But for estate and gift taxes, they really haven't given us much direct guidance with respect to that. And so that's something you need to look at carefully and determine what you have. And if what you have is some sort of partnership or pass-through type entity, then the rules aren't clear, and you may want to put in a blocker entity in order to insulate yourself from tax so that you have assurance that it's okay. I'm aware of the time here. There's a couple more things I want to mention before concluding. One is debt, because that can be important. Generally, if you have debt issued by a U.S. person, that's regarded as a US Situs asset for estate tax purposes. There is a very useful exception for these rules for what we call portfolio debt, where if it qualifies as portfolio debt, even if issued by a US person, it won't be subject to US estate tax. And interestingly, the interest paid on portfolio debt is also not subject to US withholding, as it may be for other debt. So we frequently try to, where possible, structure debt as what we call portfolio debt to avoid these rules. There's also a useful exception I'll mention in the US-South Africa estate tax treaty that can sometimes help with respect to debt. So I'll keep that, you should keep that in mind as well. For gift tax purposes, again, debt is generally intangible and not an issue for gift tax purposes when transferring it. I do want to mention real estate, because we do have a lot of South African families that invest in US real estate, and that's another one of these categories of assets that's problematic for both estate and gift tax purposes, and also for income tax purposes, because if the real estate produces income, you're going to pay US income tax on that, as opposed to, for example, the sale of shares and that sort of thing, which I mentioned before. If you sell, a non-resident sells US real estate, you're going to pay income tax in the US on that as well. Generally, therefore, when buying real estate, because of the low exemption that we have for real estate, we do try to put in some sort of blocker. It may be a blocker company, it may be a trust again, and it's important to do that, as I say, before you acquire the real estate, because otherwise it will be a problem to transfer it, because if you try to gift it away, it'll be subject to gift tax. If you sell it, you'll pay an income tax if it's appreciated. So again, it's very important to do this planning ahead of time. In this whole area, it's important to keep in mind that there can be substantial savings realized by doing planning. You can put in blocker companies and such so that you don't have a problem with this tax. But it's good to get advice so that you can look at the specific investment and see where it falls in. The other thing I just wanted to mention in closing is that you may have heard that there are potential legislative changes in this area. There are proposals to reduce the exemption that applies to US citizens and residents down to perhaps 5.5 million, 3.5 million, maybe even less. We don't know. There are no proposed changes to either reduce or increase the $60,000 amount. We haven't heard anything about that one way or the other. There are also potential changes to maybe replace the estate tax or add to the estate tax with an income tax on death. We don't know where that's going to go and how that might apply to non-residents with US assets, if there's also going to be an income tax that we need to worry about that could apply. We also now, if you are a US citizen and you have property included in your estate, you get a stepped up basis for US purposes. They may eliminate that as well. So that's another potential change that's here. So we don't know what these changes are going to be, or when they're going to take place, or when they'll be effective. For they might even be retroactively effective. They do that sometimes. So keep tuned. There may be future developments to bear in mind here. But I do want to leave some time for questions. And Flynn, please.
Thanks, Dan. Yeah, sure. A lot to take in. And I guess it is an environment that's ever changing. and I appreciate you helping us stay on top of it. There are a couple of questions. I thought a really good question was, if a non-US trust with non-US beneficiaries holds US shares, would that be considered a situs asset on death of the donor?
I'm sorry, a non-US trust with non-US shares and
No,
non-US benefit?
with non-US trust with non-US beneficiary, but that holds US shares.
Okay, it depends on the trust. If, for example, the trust is revocable, to give you an example, let's say the settlor settles a trust, puts $1 million in the trust, but they buy U.S. assets, and the settlor has the right to revoke the trust during his lifetime. That would be subject to U.S. estate tax because the settlor's retained an interest in the trust that's impermissible, sort of deemed impermissible for estate tax purposes. Where if it's revocable, then that's a relatively easy answer to the question. If it gets more complicated, if you've retained some other interest in the trust, and the one we see most frequently, to which there's, again, no clear answer, unfortunately, the IRS seems to be trying to avoid us, is let's say the settlor remains a discretionary beneficiary of that trust. That's the one we tend to see most often. And the reason that's a question is because under US law, if one sets up a trust and they remain a beneficiary of that trust, even a discretionary beneficiary of that trust, and they go into bankruptcy, their creditors have the right to get their assets. At least that's historically the US law, and still the law in most states of the United States. That a creditor of the settlor, if they're a discretionary beneficiary, can get at the assets. And the IRS seized on that some years ago and said, well, okay, that means you've retained an interest in this trust, your creditors can get at it, and therefore we think it's subject to US estate tax. Now, a number of states in the US have now changed their laws, so that's not the case. And in many foreign countries, that's not the case. I mean, I've looked specifically at any number of countries and been advised that creditors, under any circumstances, don't have the right to get at those assets if it's discretionary. And so the logic should be that that's okay. But the IRS hasn't come out and said that in so many words quite so specifically. And so, you know, we do have some measure of uncertainty still with respect to the issue. But if it's clear that a creditor can't get at those assets, I think we have a very good position we can take, that that's all right. And so that's the thing that you have to watch for. The other thing is, though, that if it just depends on whatever other control a settlor might have over the trust. If it's one that is deemed to be too much control, then you could run into a problem if the trust has US assets in it. As I say, like a power to revoke or be added or be a potential beneficiary of the trust. If you could, for example, fire the trustee and hire yourself to be the trustee to manage where the money is going to go, that would be an impermissible control. So we will frequently, in situations with clients that have trusts like this, if they want to acquire US assets, we can take a look at the trust and say, okay, we suggest you change this or change that, and then you're good to go. And the assets won't be part of your estate for US estate tax purposes. Again, this is a fixable problem in many situations.
Yeah, thank you. And you did mention, and you touched on gift tax. So I guess another question would be, so if a donor was making cash payments to children in the US and that donor was outside the US, and then he or she became a resident of the US, would then US tax, would they become a US tax resident and have to pay tax on those donations?
Great question. Not if you do it after you come to the US. And so that's the reason I say I think it's a great question is a lot of the planning we do for clients is if they contact us before they get to the US, we can do significant planning with having them transfer assets, let's say to trusts, before they get to the United States, which can ultimately save them and their estates and their children's estates significant tax going forward by making those gifts before they come to the US. And it either can be direct gifts to their kids or gifts to trusts. We will frequently do gifts to trusts in that context. And get a very good result because although you may end up having to pay US income tax if the settlor is the one coming to the United States on the income from those assets, you do keep the assets out of the estate and gift tax net. And if you do it before you come to the US, it's exempt forever. I mean, you can pass on to children, grandchildren, great-grandchildren, because our generation skipping tax doesn't even apply if the trust is settled by someone who at the time of settling the trust was a non-resident of the US. So it's really important planning that you can do before coming to the US. And sometimes we'll use multiple trusts for these purposes, either for multiple kids, multiple branches of the family, multiple rights with respect to different trusts that you want to have. If, for example, you have one pot and you want to keep some access to the funds, maybe we make the settlor a discretionary beneficiary of that pot. And then we may have another pot that's really, the settlor says, I just don't need that money. Well, maybe we make them not a discretionary beneficiary of that pot so that we can better protect the asset that way. But it's an important planning technique and one we frequently use.
I know we've only got 2 minutes, but I thought I'd ask the final question. What is required of an SA executor if they are winding up an SA resident's estate and that resident has US shares in their portfolio?
They're going to need to deal with the tax on those shares. And we have, over the years, represented a number of executors who have in the estates they're administering shares in US companies, for example. And first of all, as a practical matter, in order to transfer them, they're going to have to make sure their US tax obligations are satisfied. And depending on the extent of the assets, where the assets are, again, if we're just talking about shares, that's not too complicated. But generally, they won't be permitted to transfer them to the heirs until they get a tax clearance certificate in the US showing that that all the necessary US taxes have been paid. So, and that can be a cumbersome process, as I say, particularly when you're dealing with non-US executors. I've seen situations where they've purported to pass out all the assets without getting these clearances, and then they find out no, they actually can't pass them out. It can be very cumbersome, and one that you have to look at. I mean, sometimes depending if there are no U.S. brokers or anything involved, it may be there won't be anyone to stop it. But there could be still a personal exposure for the executor that they may not want to have to live with. So,
thanks, Stan. That's all the time we have for today. 3 o'clock on the nose here. Thank you very much for all your insights today. Really enjoyed listening to what you had to say. It was very informative. Thank you, Sarah, for putting it together. And I know Sarah would like me to reiterate to everyone on the call that if you have any questions, please reach out to Sarah and her team. They're there to help, and they can take any questions that you may have going forward. And once again, Stan has kindly agreed to share the presentation and the recording, so we will share that afterwards. Everyone have a great Monday further from here. Keep safe, look after yourselves. And once again, thank you for joining us today. Cheers, everyone.